The MC Singla case on December 10th is likely going to be very short. At the start of the hearing, the bench will almost certainly apply the why test. The judge will look down and ask, Counsel, this petition has been pending since 2016. Why is December 2025 the critical moment? What has changed that means we should prioritize your case over matters that were filed even earlier in 2014, etc.?
It's either a moment of judicial breakthrough or a trap, and the natural impulse for the uninitiated would be to defend the Singla case itself, to start arguing why the pensioners deserve updation. Is that a common mistake?
It is the fatal mistake. The moment a lawyer starts talking about the details of the pension scheme or why the bank's decision was unconstitutional, the judge will just cut them off. This is an interlocutory application or IA. We're not here for that today.
Exactly. The strategic advice is crystal clear. Do not argue the merits. You have to stick strictly to the prejudice caused by the delay itself. As the counsel, your enemies at an IA is the calendar and the court's docket, not the other side. That's a crucial distinction. An interlocutory hearing is an argument about the court's schedule, not the law.
That's a crucial distinction. An interlocutory hearing is an argument about the court's schedule, not the law.
So in first 120 seconds, the vital, maybe the specific high impact, effective arguments a counsel must make is the super senior citizen and right to life arguments. The MC Singla counsel must focus on the age and health of bank retirees who are literally dying waiting for justice.
So, let's unpack the forthcoming high-stakes procedural fight with the Supreme Court and not IBA or the government. But before we do so, namaste, I am Priya Chakraborty and my co-host is Nisha Bhattacharya.
For the MC Singla interlocutory application hearing on December 10th, it's critical to understand this is not the final judgment hearing. This is a high-stakes request for expedited listing. It's a demand to break free from the judicial queue.
And what's so fascinating here is the function of the IA itself. It's a request made within an ongoing case, asking for some kind of interim order. In this scenario, the IA is basically demanding the court take the main matter out of its ordinary sequence and set an early final hearing date.
It is the ultimate definition of judicial triage. The Supreme Court's docket is just overwhelming. The lawyer's job here is to prove in a matter of minutes, seconds even, that their client's case is on death's door and requires immediate judicial surgical attention.
That sets the stage perfectly. Because it was filed way back in 2016 and because of its age, dating back to 2008, MC Singla now falls into a category the courts call an old regular matter.
Old regular matter? I mean, that sounds so bureaucratic, but what does it actually mean for MC Singla and the thousands of bank retirees represented?
It means that under the court's normal cycle, this 2016 case could easily wait another 5, maybe 10 years for its final hearing. And that is the real injustice the IA is trying to cure. The petitioners basically arguing that the delay is no longer just some procedural annoyance. The delay itself has now become a substantive injustice to retirees.
And when you look at the raw facts about the case, like the timeline, the stakes are horrifyingly clear.
We're talking about an erosion of retirees' promised pension value by a staggering 80% over the last 20 years, mostly due to inflation. For a retiree relying on that fixed income, that's not an inconvenience, that's an existential crisis.
And that's the core legal leverage. The council has to translate that devastating financial reality into constitutional language. They'll argue that this delay risks irreparable harm to fundamental rights under Articles 14, 300A, and crucially Article 21, the right to life.
Hold on, Article 21. If the argument is just that the delay is eroding their income, why isn't every long pending civil suit considered a violation of Article 21? Where's the line here?
That's a key question. The distinction, it lies in the nature of the litigant and the nature of the claim. For a senior citizen who is relying on a fixed pension, Article 21, the right to life, is interpreted as the right to live with dignity. And when court delays essentially confiscate 80% of your expected income, leaving you vulnerable in your final years, well, that crosses the threshold.
Also, it infringes on the right to dignity, to life itself. The urgency is just amplified because senior citizens face a biological deadline. They literally risk dying of old age before the verdict comes. Okay, that brings us right to this procedural showdown on December 10th.
Given the gravity here and the number of people affected, you'd think the court would set aside hours for this. But we know the reality is much, much harsher. The bench will literally allot several minutes, maybe an hour maximum. This isn't a protracted debate, it's the legal equivalent of a 2 minutes fire drill.
I can't believe they only get literally minutes. If time is that tight, the lawyer can't waste a single syllable on emotional appeals or legal philosophy. They have to hit the specific criteria the court demands for this kind of judicial triage.
Precisely, the court will be weighing three main elements, and they are not about the merits of the pension case.
First is urgency and irreparable harm. Are constitutional rights really being jeopardized right now? The second is public importance. Does this affect millions or is it just one person? And the third one, which is probably the heaviest on the court's mind, is purely administrative feasibility.
Can the registry actually slot this matter quickly without throwing the entire judicial schedule into chaos? The court will often sacrifice time on the merits just for administrative stability. They have to know it's doable.
The toughest hurdle then has to be the why now test. Since a huge number of the petitioners are mostly over 70, counsel should immediately hand up a simple chart showing retirees' ages, maybe their health conditions. The court knows that for elderly people, justice delayed is often very literally justice denied.
To your point, Priya, courts are jurisprudentially inclined to grant priority based on age and health, and this idea is rooted in a really old legal maxim, actus curiae neminem gravabit. It means an act of the court shall prejudice no one. The argument is that the court's own inability to deliver a timely judgment shouldn't be the thing that causes the litigant suffering.
That's a powerful phrase. I mean, if justice arrives after the litigant has passed away or after their life savings are worthless, the verdict is pointless. It's a victory won at too great a cost. The counsel has to show the court's own delay is prejudicial to surviving bank retirees.
Okay, let's imagine you, the listener, we are advising the senior counsel walking into that IR exchange before the sexy. What are the three non-negotiable points they have to land immediately?
Strategic rule number 1, stick strictly to the injury of the delay, not the injury of the underlying policy. If counsel starts arguing about why the retirees deserve the pension, the judge will cut them off. The argument must be solely about the prejudice caused by waiting.
Okay, pure focus on the procedural harm. What's next?
Strategy 2, focus heavily on retirees' age and health. Use a visual aid if you must. Counsel should hand the bench a one-page chart, oath, a thick binder, a single page showing the age, medical condition of the most affected retirees, and how many has passed away while waiting. This appeals directly to the empathy built into the court rules, specifically Order 15 of the Supreme Court rules, which gives priority to senior citizens. It's just an immediate, undeniable piece of evidence that the clock is running out for many.
What's strategy 3? The one that sort of shifts the focus from help me to let us help you, your justices.
That is the incredibly persuasive covered matter angle. The counsel has to argue that resolving this 2016 case will settle a crucial point of law that will in turn resolve 500 other pending cases clogging up high courts across the country.
Wait a minute. If the counsel successfully argues for expedited listing based not on the suffering of their clients, but because their case is an easy way for the Supreme Court to clear its own backlog, is that really justice for the individual or just administrative self-interest?
It's a win-win for retiree and the Supreme Court. That tension is exactly why this argument is so potent and so often successful. The Supreme Court is drowning in filings.
A lawyer who promises to remove 500 downstream cases from the system is offering immense value to the bench. It transforms the petitioners from needy litigants into sort of partners in judicial administration. It's a very calculated strategy.
So the counsel has to show they have the master key that unlocks a whole chain of litigation. And finally, linking all these, they must be ready for that ultimate challenge. What becomes infructuous or pointless if we don't hear you now?
Counsel must show immediate, irreversible prejudice that the case will literally become unnecessary. And for the bank retirees, the answer is clear. The continued erosion of their pension value through death and inflation renders any eventual verdict meaningless. The remedy must arrive before the patient expires.
This procedure, using an IA to get expedited listing, is clearly a recognized critical tool. It's important for you listening to see how this strategy has worked in other high stakes situations. It's a tactical application of existing court rules.
Exactly. The strategy hinges on connecting that urgency to either systemic impact or constitutional necessity. Let's look at a couple of quick examples to see how others have successfully broken the queue.
Okay, let's start with an area that seems miles away from pensions, massive commercial disputes. How do you argue that a business law case needs to displace older matters?
A perfect example is Swiss Ribbons versus the Union of India in 2019. This was a huge case challenging the constitutional validity of the entire Insolvency and Bankruptcy Code, the IBC. The IA for expedited listing worked because the lawyers argued that the uncertainty around the IBC wasn't just affecting two companies, it was paralyzing the entire national economy.
So the argument wasn't just my company is losing money, it was the entire country's economy is stuck.
Precisely. Lenders wouldn't lend, lower courts were stalled. The Supreme Court recognized that commercial certainty was an urgent public interest. The national economic impact was such that the case jumped the queue over matters that were years older.
That shows economic urgency. So let's pivot back to the single argument urgency, because the delay itself is a rights violation.
For that, you look at Hussain and another versus the Union of India from 2017. The petitioners argued in their IA that the prolonged delay in hearing their appeals violated Article 21, the right to a speedy trial.
And how did that one succeed?
The court agreed that the systemic undue delay violated a fundamental right, including in lower court cases waiting over 5 years. It basically cemented the idea that delay, if it's substantial enough to infringe on Article 21 rights, is a valid reason for immediate listing.
That's the precedent the MC Singla Council needs to lean on most heavily. The argument is if the right to a speedy trial can be asserted by IA, so can the right to dignity for a pensioner.
Okay, so we have this rapid fire hearing on December 10th. The council has the age chart, the covered matter angle, the precedents from speedy trial cases, and less than 2 minutes to execute. What are the three potential outcomes?
Okay, so we have this rapid fire hearing on December 10th. The council has the age chart, the covered matter angle, the precedents from speedy trial cases, and less than 2 minutes to execute. What are the three potential outcomes?
Right. There are three main trajectories. The best case is that the IR is allowed and the court directs listing for final disposal on a specific date, say early January 2026. That completely breaks the logjam.
The middle case is they grant liberty dimension. This means the council is authorized to go before the Chief Justice once all the paperwork is complete. It signals goodwill and intention to list, but it's not a guarantee of a specific date.
The IA is simply dismissed with the note to be listed in due course. That means the petition goes right back to being an old regular matter and continues its indefinite wait in the queue.
So, what this all means for the people following this case is that the December 10th hearing is purely a procedural pivot point. If expedited listing is granted, it decisively breaks the 8-year cycle of adjournments and shifts the momentum toward a resolution. If it's denied, the retirees are just back to waiting for the wheels of justice to turn at their glacial pace.
That's the key takeaway. This is not a battle over policy or philosophy yet. It's a short procedural joust where the right to speedy justice and human dignity are weighed against the inescapable reality of the Supreme Court's heavy docket.
It provides a really necessary, if frustrating, look at how the administrative challenges of the highest court directly impact the lives and fundamental rights of millions of people relying on justice arriving before it's too late.
That's the thought we leave you with today. Please share with family, friends, and comment.